Hi everyone, I'm Wendy Chris. I'm super excited to be part of the awesome team number one. The topic I've chosen is HIPAA compliance and its impact on IT, mobile devices, and health information exchange. This was definitely a super hot topic within our last discussion assignment. So I hope that this presentation imparts a ton of knowledge regarding the latest revisions that are associated with HIPAA and electronic health information as well as exchange. So here we'll start with some important terms. Just wanted to bring a couple to your attention that you'll hear me use frequently throughout the presentation. The OCR, the Office of Civil Rights, and of course PHI, and EPHI, which is Electronic Protected Health Information. Okay, everyone, so this is where it began. Health Insurance Portability and Accountability Act was implemented August of 1996. At that time, the Secretary of Health and Human Services was called on to publish standards for the electronic exchange of information, hence the security rule that was finally implemented in February of 2003. All of these are collectively known as the administrative simplification. If you look here on this chart, HIPAA is very confusing. There are 5 titles to HIPAA. For healthcare professionals in our institutions, we are only concerned with Title II. This covers the privacy, security, and electronic data. So this is what we will implement into our practices to maintain compliance with privacy laws. So the goal of the security rule pertaining to electronic protected health information is to assure the confidentiality, integrity, and availability of that information, and also to protect the privacy of individuals' health information while allowing covered entities to adopt new technologies to improve the quality and efficiency of patient care. And if the 2003 revision wasn't enough, the latest revision, finalized in January of 2013, was the Omnibus Rule. There were 4 final rules with this. The update improved patient privacy protections, gave individuals new rights to their health information, and also strengthened the government's ability to enforce the law. So the ORC is in full effect. They are continuously establishing programs to make sure that all covered entities are complying with HIPAA laws, HIPAA rules. So many ask, what's the difference between the HIPAA privacy rule versus the security rule? The HIPAA privacy rule is one big umbrella that covers everything. The security rule was an addendum to the privacy rule and is specific to the electronic exchange of protected health information. So who's covered by the security rule? This has not changed. It's exactly the same with the exception of the business associates. There are more detailed guidelines regarding the business associates and the business associate agreements that are required when healthcare entities utilize services outside of their institution. So what's the bottom line? The latest security rule says that we are to protect our EPHI information. We are to anticipate any threats. We are to have security measures in place and to be prepared for such threats. We are to have a workforce that is compliant with the security rule. How do we do this? They give specific details, and they are very long processes, but it involves a risk analysis and management. The risk analysis and management is broken down into 3 categories: administrative safeguards, physical safeguards, and technical safeguards, all pertaining to electronic medical records and technological transfer of protected health information. So administrative is basically your processes, documentation of those policies and procedures, ensuring that there's training for your workforce. Your physical safeguards, your facility access and control, workstations? Are they in places that are private and not exposed, where unauthorized users have access to it? Probably the biggest piece is the technical safeguard, because the majority of breaches come from this area alone. Antivirus software, multi-factor or two-factor authentication, data encryption, de-identification of data, firewalls, and mobile devices. These are the largest areas of breach under the HIPAA rule and the security rule, the technical safeguards. So we must ensure that we take aggressive and appropriate measures to make sure that those breaches do not occur. And here are the details that I promised you regarding the risk assessments. This is the administrative safeguards. If you'll notice, when you're going through these you're going to go through every one and make sure that these processes are in place. You have what is the standard, you have what is required, and then you may have one that says it's addressable. So addressable means, okay, it's not required, this particular measure is not required, but you must implement a measure that is equivalent, that's going to work best for your clinic. So it's not a requirement, because it is, but you are able to utilize processes that works best for your facility, since no facility is the same. And here are your physical safeguards of the risk assessment, again, outlined in nice detail for you to go through and ensure that these processes are in place in order to be compliant when there is actually an audit. It is not if, it is when. And here are the technical safeguards of the risk assessment. Probably an area that needs even more attention. Not that the other two aren't important, but the majority of breaches happen in this area, and it is usually secondary to employees or business associates. And here are some interesting facts. This was actually received from or retrieved from the OCR portal. So these are actual breaches that took place or are being investigated from 2016 to 2018. And the types of breach are here in this column. And then, of course, the location of breached information, email, laptops, network servers, email, electronic medical record. Here we have email, 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 email. Again, this has a lot to do with employee training and promoting an understanding of why this occurs via email. It's extremely important. Again, numerous email issues. Numerous. Employees must understand encryption and all of those things that are associated with sending protected health information via an email account. So as you can see here, the Office for Civil Rights, the OCR, they do not play. They are very serious about these penalties, conducting way more audits, numerous audits than they ever have before. This was a task force that was put into place just to monitor HIPAA violations. They collected over $49 million in the last 3 years. The average settlement in 2017, $1.94 million. Those are some very stiff penalties for mistakes made by the workforce that could have been corrected through training. Not saying that they all were, but many of those were. Okay, so our main point, HIPAA compliance officers, there is a new rule in town, the security rule, which is going to require extensive assessment, security risk assessment, and management. This is imperative to ensuring compliance. Those administrative, physical, and technological safeguards, it's going to be critical to go through those assessments and implement those things into your practice. Workforce compliance is imperative. Continuous training, assessment, evaluation, and holding that workforce or your employees accountable is going to be imperative to compliance. Well, thank you everyone for tuning in. I know that I've crammed a lot of information in a very small amount of time, but please feel free to reach out to me if you have any questions. Thank you.